Lastly, some of you, if your friends are at AAT, you have to be careful doing the AAT. I understand AAT is a difficult, it's a different battlefield. A lot of migration agents who are not experienced or have no litigation knowledge or experience wanting to do the AAT for the clients. They can if they want to. But look, in that battlefield, if you are not equipped with the biggest guns and be trained with a lot of experience, it's more likely you're going to get shot and killed. So it's difficult because your case will be interviewed, interrogated, asking questions separately, checking for inconsistency, or focusing on some particular legal issues. Example, the time of application, time of decision criteria. If you don't distinguish that clearly enough, it's wrong. You won't be able to win. And, you have to provide sufficient updated evidence because so many years have happened. You have to prove your relationship is continuing. But remember, of time of application criteria, if you might have to prove that your relationship was there before at the time of its application. And sometimes they will question you. Most of the time, if they have suspicion regarding your relationship, they will ask you separately and looking for inconsistency in your answer. Will things be 100% consistent? If your relationship is genuine, it is less likely or almost impossible for everything to be matching 100%. That's a reality. How can you prove that everything you answer, unless you prepared everything over and over again, that everything's genuine? But the way you answer it, the degree of inconsistency will affect the decision maker. And also, I remember I had an important case that you sometimes have to play mind games. I had a Schedule 3 case years ago, and the applicant also had serious health issues as well, and visa cancellation, Schedule 3, etc. They do have a child, and I asked them to bring the child to the tribunal hearing. That definitely plays a part in the decision maker or the member's head. So you have to prepare your clients, because the migration agent won't answer the questions on behalf of the applicant. It is not court hearing. Tribunal hearing is about the questions that your applicants answer. The migration agent's role during that hearing is quite minimal. So I think the important role for the migration agent is to prepare a written submission earlier to address all the legal issues and key reasons and build up the foundation or impression you wanted to achieve for your case, for your applicant, and then prepare your applicants during that interview. And that's the thing. And if you have serious Schedule 3 problems after you lodge it, but you don't know when your case will be assessed and you're rich, during that bridging visa for your first partner visa, you can depart Australia and lodge another offshore visa. You can do that. There's no problem doing that. And it's just really expensive. That's all. But if you can afford it, you can do that. So in that case, you will have double opportunities. Whichever get decided first, then you get a safeguard. Anyway, these are only applicable in difficult situations, and we wanted to tell you that we're very experienced in those situations.